Commonwealth v. R. Oberle.
Mr. Schnipper, good morning.
Good morning. May it please the court. I'm Merritt Schnipper for William Oberle. This was a case in which the defendant's need to use peremptory challenges to protect his right to an impartial jury was paramount. He was charged with a crime that's almost universally despised. The need to protect himself against subtle juror bias is well illustrated by the fact that 7 jurors, or roughly 25% of the veneer, either had prior personal experience with domestic violence or disclosed bias against accused domestic abusers. Notwithstanding this important need, the judge prevented the defendant from using a peremptory challenge against juror 15 based on her mandated reporter experience. And
But just on the facts, because you seem to go to depend on this point quite a bit, and I'm a little puzzled by it. I understand it's abuse, but mandated 51A reporting is about child abuse. It doesn't, I mean, I guess I'm just, there is a distinction, a fairly large distinction between what a teacher may have to report and the idea of domestic violence, I think.
well, I would say that in 2 parts. First, if you look at the 51A statute itself, it's not simply about parental abuse of children. It's about,
No, it's about caretakers.
right. Well, it's really about abuse suffered by children from any end that is picked up on or detected by people in caretaking positions.
But that's child abuse, not domestic violence.
Correct, but obviously there's a significant amount of child abuse that takes place in a domestic violence context, and it's as counsel.
But she didn't say that. I mean, she didn't talk about domestic violence, the juror, 15. She didn't talk about domestic violence.
Well, what she did is in response to a question about her own personal experience with domestic violence, chose to disclose not only her mandated reporter training, but her experiences in detecting and reporting abuse. So then what happened is that the judge said, there's no 51A issue here, and moved her right away into a separate question. So there really, and if you look at the transcript, she's actually cut off in mid-sentence by the judge moving away from the inquiry.
But that's the for cause part of it, right?
It's not a question of the for cause, it's just a question of she was still, in her individual voir dire, she was still moving into the explanation of what her personal experience with domestic violence was.
But I guess I'm trying to find out from you is, on the Batson source analysis and the findings made by the trial judge, he found, I think he used the word sham.
I think pretext.
Well, he said, yeah, there was something like that. Where did he fall short in his findings so that he didn't support the Batson source?
Well, he fell short in his findings because he simply made a conclusory finding that it was a pretext or that it was not genuine, rather than laying out the factual findings to underlay that conclusion, which is what this court said is necessary in Maldonado in order to determine that there has been a thorough analysis of both the adequacy and the genuineness prong. So it's not just a question of a judge taking a gut check and saying, what you're doing isn't genuine over here. It's a question of a judge saying, based on the record, based either on my observations of you and your behavior, or in the way this juror stands in context to the rest of the voir dire, the veneer, this juror either has a unique quality that he or she does not share with other people, or actually you're trying to strike someone on the basis of a claimed sort of attribute that you've already acquiesced in multiple people being seated with that same attribute, thus supporting my finding that this is not the genuine reason for your strike.
Could I ask you about establishing the pattern? Because if the judge made an error in deciding that there was a pattern, then the defendant wouldn't have had to justify any of the challenges. Given what the trial attorney said, that there were, I guess most of the jurors who came up in the first group were women. So if you do challenge women in that situation, is that a pattern?
That, I think, is really sort of the preliminary issue that's presented by the case. Before you get to the juror against whom the strike was not permitted, that's juror 15, you have jurors 1 through 8. 7 of those are women. 3 are excused for cause, 1 is seated, and then 3 are the subject of strikes. So when the judge makes, this is an unusual Soares-Batson case because he doesn't find the pattern and prohibit a strike in the same context. What he does is, he first says, I'm making an initial finding of pattern, I'm gonna make you give me a reason. He says, juror 7, that strike was justified, I could tell. She said, I've lost faith in the justice system, but these other two people, you're going to need to give me a reason. And counsel says my client wasn't feeling uncomfortable with them and didn't like sort of their vibe. He says, that's not going to do it. And then he says, what you've given me is completely inadequate. I don't have any reason to doubt that you're being truthful. I have no reason to doubt that. But the substance of your reason is that it's no reason at all. But then he allows the strike of juror 8. So presumably, that we have to infer from that he did not find that strike was motivated by bias. Because if that strike had been motivated by bias, if he had concluded that, he would have been required to have that juror
But didn't Judge Prasad say that he thought that the reason given was genuine?
That's right. So
You have to find both adequacy and, that it's not adequate and genuine. So he could not.
Sorry.
So in other words, there wouldn't be a decision to allow that strike to be used.
So, right, because it was the genuine reason. So you have to find a lack of genuineness in order to prohibit a strike. Right. So in this case, he basically said, I found a pattern, meaning sort of more in the mathematical pattern concept rather than the pattern of discriminatory use concept. And he
So
said,
are you arguing that the implicit finding of a pattern was erroneous?
I am, and I cite to the Green case from 1995 for that proposition.
But I mean, this is really hard for
Yes,
a
it is.
judge.
I believe you.
So,
And you
I
all
mean,
know more about that than me.
Yeah, we all sat in the Superior Court, and we all know. So, I mean, he's looking at you're looking at more than a pattern. Judge Broussard, I think in this case, as was his custom, gave individual voir dire, correct?
Yes, he did.
So he knows a fair amount about what this person is saying. And is it unfair for him to say that of the 3 of the 4 jurors who were not seated or removed for cause, the defense counsel strikes? And now, can't the judge also consider in deciding whether that is enough of a pattern to require an explanation, that he's listened, he's seen the questionnaire, he's listened to what these people said?
If the
And
question
he doesn't,
that you're asking...
he says, I don't really sense that there's a great reason to do it.
Well, if you're asking, does the record satisfy the threshold for him being permitted to say, I see enough of a pattern that I want to begin the SOARS protocol and make you give me a reason? Yes, it does.
Okay,
Right? Because
I
all that
thought you said it did not before.
I'm not saying he was unjustified in saying, let's begin. What I'm saying is, when he completed that, after Juror 8, he had not made the findings necessary to what a finding of pattern of discriminatory strikes is.
But he had said, I now find enough to say, I'm concerned enough that I want you to explain the next one. That's his
Right. I mean, I haven't
razor's
taken
edge.
issue with
That is a
initially.
pattern. I mean, you have to get to the pattern to even say that, what Chief
Correct.
Justice
So I
Gants
think
just
that's why
said.
the word pattern gets used in 2 meanings here. One is a pattern, literally just a repeated instance of something similar, and one is a pattern of things that are motivated by an impermissible goal. So the pattern of discriminatory strikes is sort of what we find after stage 3 of the SOARS analysis. The noticing a pattern of strikes against members of a discrete group is what initiates the beginning of the 3-part protocol.
And to complicate your life, we've said a pattern could be 1.
In the case of a person the group to which they belong is of an extreme minority in the veneer, which of course this is the opposite of that. This is a 50-50 veneer. And I think to the extent that I am talking about the pattern decision, I think when you basically have 2 strikes that the court says, well, I'm not really sure about them, and you have a veneer that's half made up of the group against whom those strikes have been launched, I think it is precipitate to move in that quickly.
But wait a minute. So before we get to bona fide reason and all of those issues, so what if the first 4 jurors were Hispanic and there's 3 strikes? That could be a pattern.
Any group that's identifiable could be a pattern.
So the fact that there were a lot of women at the beginning, it doesn't bother me that he thought that there was a pattern, because the reasons didn't make any sense.
Well, it may not bother you, but what I think it is, it's very notable, and I'm not saying it it sends the SOARS protocol off the rails. But what I am saying is it problematizes it a little bit, because every juror who is called for individual voir dire is the member of some discrete group.
Well, I mean, if we had, the first 8 jurors are all women, or
Right.
10, no men at all. And it happens that the defense attorney strikes 4 of the 8. Well, I suppose you could say there's a pattern of women, but since it's 100%, I mean, isn't that part of your
Context,
point?
yes, that's a very large
So you would
part of
say
it.
in that scenario, it would even be wrong to say there was a pattern asking for an explanation, or you might.
I think you have to look at the individual facts of each case, but yes, I think it really strains that analysis when the group is uniform, so to say that, so like, let's imagine you had, a group that was, the first 15 people are all from the same group. And maybe you are the type of person, like the defense lawyer in this case, who probably for very good reason needs to be very vigilant about use of peremptory challenges, and I would notice that he used all of them, the Commonwealth used 2. You may feel, I need to get out here and start striking. We all have seen it. Well, you get farther down, you've used your strikes, now you're arguing for cause, and maybe you end up with some people you would have struck way down the line, but you have to act now if you think there's a basis for a strike.
Let me ask you, though, I mean, the judge looks out at the courtroom. What about the veneer as a whole? Didn't you say it was roughly 50-50 male, female?
Roughly 50-50.
So the fact that you've got maybe front-loading of the women doesn't mean the judge can't take into account who's coming.
Well, that's
And-
right. So the
and
judge
also
can
have
look
some
ahead and
suspicion here,
say,
given the nature of the crime, that the way the peremptories are going to be used is to try to get rid of women.
sure. So that, I mean, if we're talking about what's permissible for a judge to begin thinking about these issues and begin engaging with, I'm completely with you. But the greatest issue and the serious problem that requires reversal of this conviction here is, although I argue that his precipitate finding of pattern is another reason, the real reason here is that by the time you get to juror 15, he's basically said to defense counsel, you're gonna have a lot of trouble striking a woman from this jury.
If we can
And then he
turn-
gets, sorry.
If we can turn it to juror 15, because that's,
Yes.
I think, the heart of it. What do you say is the standard? You say that a judge may deny a strike only if the judge finds that the purpose is solely gender. Is that
Well, I'm taking that from SOARS and all the cases following it, that, that people may not be removed from a
there's
jury
other
solely
language
on
that
the
speaks
basis
about
of their...
it being substantially motivated.
Well, whether it's solely or substantially motivated, the question that I'm presenting to the court is, when you have a juror with specialized expertise in the area that is the focal point of the case, and that is the basis, because there's a whole concept of group neutral rationale, which we frequently see as something like the person works in auto sales, and this case involves someone who drove recklessly, or these I would call group neutral, but somewhat vague. What we have here is a deeply case relevant rationale, where a person says, my client is accused not only of an act of domestic violence, but that is going to be tried by the Commonwealth as a person who's been engaged in a long-time pattern of domestic violence.
So your position
Yeah.
is that the group neutral reason that was proffered by counsel below was legitimate?
Not only that it was legitimate, but that it was so sort of spot on to the issues of the case that you can only really support and uphold on appeal the disallowance of that strike with very particularized findings that the court here didn't come close to making about exactly why a person who says to the court, sua sponte, of her own volition, when asked about her experience with domestic violence, I am a mandated reporter, I have experience reporting, I've experienced detecting, I've resulted in seeing children taken away from their families because of the work I've done in detecting abuse, and then counsel says to the judge, I want to strike her, she's familiar with these patterns of abuse, and I would note for the court that preliminary to this, there had been a pretrial hearing at which the court said, I'm going to be allowing in prior bad acts evidence of other acts of abuse by the accused to show the pattern and the nature of this relationship.
To what extent do we give the trial judge discretion in this?
I don't think you should give him any in this particular case because, and I would point the court to its Calderon decision summarizing what constitutes adequate findings, sufficient findings to justify that sort of deference, and there it was sort of based on all the circumstances. And I would say he's basically here, he's saying the same thing. I've examined her with care, I see no reason. But that's suggesting that's the for-cause standard. The reason is not that she's going to be biased. The reason is that counsel believes her specialized training is going to have the potential to hurt his client, and under every precedent we have, like, he has the right to keep that juror off the jury.
Now, since you're not going to get a chance to stand up again, what do you say about the Commonwealth's suggestion that if you're right, that it's not automatically structural error?
Well, he's been wrongfully denied a peremptory challenge, and this court reaffirmed in Hampton after Rivera v. Illinois that it was sticking with the structural error standard for wrongful denial of a peremptory challenge. So all I say is counsel's incorrect. If there are no other further questions, I'll rest in my brief.
One more. I mean, that's obviously a problem for us. I mean, I think you're right, it is structural error, but it speaks to the issue of to what extent do we give deference to a judge where the result would be an automatic reversal. I mean,
Here's what I would say about that. You know, I appreciate the need for judicial deference, especially from the appellate level. I also think that we are at an issue that is at the deepest core of a criminal defendant's jury trial, right? And this court has been unrelenting in its refusal to back away from that standard for that very reason, that Article 12 is protective, that we have the right to an impartial jury. So what you're really saying to the court with a reversal is findings need to be made that are just, and I know it's hard, like you're trying to seat a jury, you're moving through jurors, but if you're going to prohibit a criminal defendant from striking a potential juror on the basis of a highly case-relevant piece of expertise, you need to do more than say conclusively, I'm simply not convinced that this is anything other than a pretext. You need to say, even though she has all these trainings, and even though, then you need to explain why. And in both, that pointed the court to Foster v. Chapman, but even in your own precedents, there's discussions of referencing, the behavior of counsel and the defendant. As much as it could be hand gestures, it could be the way they handle their papers, it could be the way they look around, the manner in which they speak. I mean, a judge is right there to dictate those onto the record. It takes 2 seconds, and while it is an additional burden, I think if you're going to flip it around, to defer to findings that are this conclusory is going to have the result of making these rulings basically immune from review, and I think that's the larger risk.
okay, thank you.
Thank you very much.
Mr. McGee, but still good morning.
Still good morning. Good morning, Your Honors. May it please the court, Michael McGee for the Commonwealth. The trial court judge here acted well within his discretion to identify a pattern of the defendant and his counsel clearly excluding jurors based upon their gender. He also was clear in his findings of the adequate nature of the inadequacy of defense counsel's reasons for excluding the juror and the genuineness, excuse me.
Well, I mean, let's just get to juror 15. What was inadequate about the counsel's explanation?
It had nothing to do with the case. There's a second part of inadequacy. It's not that it's particular to the juror herself, but that it's related to the case. It's a 51A. First of all, she works at Bright Horizons as an HR person. She had taught for 15 years prior to that, and only told the judge that she had on 3 occasions reported child abuse. This is a case that has absolutely nothing to do with child abuse.
Well, but we're not talking, I mean, the question is that a reason that bespeaks trying to get women off, or is it a judgment call that maybe you wouldn't have made, but why isn't it a case-specific reason?
I would suggest that the standard here is abuse of discretion. And I would suggest that the court's findings on this were not palpable error. He took a careful voir dire individual.
It was palpable error very much.
Excuse me.
I'm just saying that, yeah, go ahead.
I would suggest that it wasn't an abuse of discretion. Essentially here, what you've got is a very careful and conscientious judge whose experience.
I agree that he's conscientious, careful, and experienced.
He's done an individual voir dire of this juror. He's asked her very specific questions about her background. As soon as he heard that she had some experience with child abuse, he responded to her and stated that child abuse has nothing to do with this case. Then flash forward. Defense counsel immediately jumps into an excuse as to why he's using a peremptory challenge here and says, she's had experience with 51As. He again states there was no child abuse. That's the adequacy finding here. And I believe it was clear, and I believe it fits within the deference standard that Your Honors.
And I guess I'm wondering whether or not our jurisprudence is wrong. Because we said in Maldonado that the standard is whether or not it was the actual motivating force, in this case gender, was the actual motivating force behind the challenging party's decision. That's what the determination is, correct?
That's correct.
So it's not adequacy. I mean, we say that we examine whether it's genuine and adequate, but adequacy doesn't look to the actual motivating force. It looks to whether basically it's adequate for cause, but that's not the standard, is it?
I would suggest it's synonymous also, and it should be considered by the court as lawful. It's unlawful to exclude jurors based upon their gender. And clearly what he was doing, he used all of the peremptory, and he, being the defense counsel and the defendant himself, used all of the peremptory challenges on women. There was a young woman from Wellesley College, had no responses to any of the questions that were presented to the entire veneer that would suggest that she would be partial. There was another woman in her late 20s or early 30s that also had no responses that would suggest she would be partial in any way. Excluded for no reason whatsoever.
Well,
And I understand that in
the
some ways
nature
that's
of
what a
peremptory.
peremptory is for, but it's also, and there's a wide discretion to a judge to make sure that for everybody involved, the prosecutor, the defense attorney, and the public at large, to make sure that women are allowed to be on juries, free of discrimination. And in fact, that protects the defendant himself. If
If you give a reason that has nothing to do with the gender, that fits with the facts of the case as it did with Juror 15. I mean, you could disagree with the defense counsel's assessment of that, but isn't that enough to get past the allegation that you're striking because of gender?
Absolutely, but that would be flipping this case on its head. Suppose, for example, the prospective juror 15 did have some experience with domestic violence. Say she did hear that the family was abusive all around, and she had explained that to the judge, and there was that finding. I would suggest there would be linked to the case. What's interesting here?
Have to link it to the case. What I'm trying to understand is what does defense counsel have to do in order to exercise the challenge that is the right of the defendant? I mean, does he have to prove that he's not being discriminatory, or can he just give a reason that makes sense and be done with it?
I would suggest it's a judgment call for the judge, and in understanding that this judge is seeing everything that's going on in the courtroom here, understanding what is going on with this particular veneer, and particular to this juror.
Well, the fact that the case didn't involve 51A, I understand that, but that doesn't mean that it was because of gender, because it didn't involve 51A.
That is, and its deference should be given to the judge, and I would suggest that here, she had no experience. This case had nothing to do with 51A.
I get
The
that.
observations are clear,
I get that.
and that's Batson. And that's the second half of that sentence, not just particular to the juror, but also related to the case. And that's what would have to have been articulated by the defense counsel. That's why it was not adequate or lawful or genuine. He was using that as pretext, and he used and I mean to be loose with words, but he used the magic language. He pointed out that it was pretext to keep females off the jury.
But it has to be both adequate and genuine. So if
Right.
a judge finds, and these are rules that both apply to defense attorneys and prosecutors, right?
Yes.
So if a judge says it was either, it has to be adequate and genuine. If a judge says it's not genuine, you're lying to me, then he's fulfilled our mission, correct?
Essentially. And that's, they blend in with each other in a circumstance like this because the pretext in and of itself is that the reason wasn't adequate.
But you have to pull them completely apart. You have to, they're distinct, maybe they're symbiotic to some extent, but they are distinct. And when a judge, this is what's really hard, it's when a judge at the sidebar is deciding that the reason isn't genuine, there's all sorts of reasons for that that just can't make it onto a record.
Agreed. And I would point to the earlier discussion between defense counsel and the judge about Juror 8 and what he had seen and the kind of challenges that the defense counsel had made before that, and identifying that razors, I think he said razor's edge, you're on the edge here, counsel. He was identifying this pattern. He was carefully, and I think that's discernible from the record, that he was carefully picking apart defense counsel's reasons and finding that they were wholly inadequate.
And that's the issue. So there's no, it's the defendant, it's the Commonwealth, it's the juror's constitutional right to serve. And when that judge is at the sidebar trying to figure out whether this is genuine or not, there's a lot of constitutional rights that go on into that are very hard to put on the record.
That's correct. And what I also think is important is not only is the judge looking at the folks that are at sidebar at that very moment, he's looking at the entire courtroom. And what the judge could see in this case is that after Juror 8, a prospective Juror 8, the next 22 jurors, 15 of them were male. So to your, Chief Justice Gantz, your initial comments about the word adequacy, it was clear, I would suggest from the record, that what defense counsel was doing was trying to remove women from the beginning of the jury because it was heavily weighted with males at the end of the jury. And in fact, it happened right away. Right after Juror 8, there was 5 men and 2 women. So it was not unfair, it was not improper for the judge to make those initial findings of asking for an explanation. In fact, he has a large discretion. And if when you're looking at a discrete class that may be excluded from the jury, that they may be depleted in that initial 7, he has that wide discretion of asking for an explanation. And that's Commonwealth versus Gary, 436 Mass 422.
Did the judge, I mean, I know with regard to juror number 8, the judge said, I don't doubt that you're being truthful, speaking to defense counsel. I gather that when the judge was dealing with juror number 15, the judge did not say that to defense counsel.
He did not.
Okay, so there's no, so your view is that the judge found that she was not being genuine in terms of what her reason was?
I think it's clear from the record, and I would suggest it's very clear from the records.
Say that, though.
He says that I find that you are seizing upon the background of the juror, and that is pretext for keeping female jurors off the jury.
Right, but in this situation, you know, in this situation, what the judge should be doing is to make distinct findings on adequacy and distinct findings on genuineness and not using shorthand.
I would suggest that in this particular case, and if you look at cases like Prunty and Obi and all of the other cases, that he wasn't shorthand, that he did identify the adequacy and the genuineness of it, and that it was reflective of the record, that it was supported by the record. I don't believe that another layer should be added to a judge's findings. I believe that there's a lot to be said for discretion and what the judge sees at that moment, what he or she sees was coming down the line. And in this particular case, I think that's right, spot on, is why this judge in particular knew the case law, identified that it was pretext, and identified the inadequacy of the defense counsel's explanation.
See, I guess where I'm concerned is it seems that inadequacy is a factor in determining whether it is genuine. But if the judge had said, with regard to juror number 15, I think you're being truthful, I have no reason to doubt that, which is what he said with regard to juror number 8. Could he then say, I agree that that you're doing what you said you're doing, which is to base it on the 51A, but I don't find that adequate.
I believe we would be at a totally different situation where he would be holding him to an erroneous standard. He does have to find adequacy. He does have to find genuineness. He did in this case.
Just wondering whether or not adequacy is simply a factor in determining whether it is genuine, and if it's genuine, it's the actual motivating factor, and then the defense counsel is allowed to do that, unless you find that it's not genuine, it's a pretext.
Although it's not explicit in the paragraph, it's explicit in his responses to defense counsel. It's discernible to the court through the record in that he states when defense counsel immediately jumps into his explanation of why he's asking for a peremptory, he says, this is not a case about child abuse. That's your adequacy. And as far as lawfulness, I would also suggest keeping females off of the jury is unlawful.
But the way you look at it, though, to separate the 2 points, is somebody can give you a completely adequate reason for a peremptory, perfectly adequate reason to strike this Hispanic juror. DA comes up with a reason, but it's just not genuine. It's a completely separate analysis. It's not enough to have an adequate reason. It has to be true. That's why you're using the peremptory.
And I think that's why, and I believe it's the Maldonado court talks about the lawfulness of it, because the judge also is making observations. As you said, these are things that don't show up in the record. Is making observations of counsel, seeing everything that's flowing from all of this, and is able to make discern whether it's a lawful, I'll say, reason for it, and not just making it up, and not just saying, well, I believe her background is like the case. In this particular instance, not only did this defense counsel bring up a point that had nothing to do with the case, he also tried to seize the judge's prior ruling by saying, oh, she's 58 years old, she's not like the younger jurors, which is not a suspect class, and was just seizing upon the judge's prior rulings. Again, going to that what the judge is looking at sidebar and might not show up on the record is the defense counsel's just continuing, just making, essentially not making an adequate or lawful statement. And I would just conclude by, and I know I have gone over, is that what's clear from the record here is, and through the entire trial, is that the judge did everything to preserve the defendant's rights and do everything to make sure he had an impartial jury through the jury selection, but also through the little things, through his instructions and focusing on the seriousness of the trial, from making jurors wear ties, instructing them several times. This is a very, as Judge Bofford understands, this is a very conscientious, experienced judge who took his time with this jury, and I would suggest that the defendant benefited from that and ask you to affirm the convictions.
All right, thank you.